Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one. It means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation, and you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
You guys go. Mr. Heath, are you ready?
Good morning.
Good morning, sir.
May it please the court, James Heath on behalf of Clayton Reddick Blackshear. Good morning, Judge. Judge, that's going to be case number 2021 CF 2409, 2020 CF 2405, and 2020 CF 1954. Judge, we're here on a trial management today, and as I mentioned, I believe it was Monday, we were able to iron out everything, and we do have a negotiated plea agreement. So my client's going to be withdrawing his previously entered plea of not guilty and entering a plea of no contest. And you're going to have to forgive me. Would you like it announced from my end, or would you like to?
If I can see it and I can understand it. Thank you, sir. All I've got, just so you know, Rachel, is just the cart, so I'm not going to bring it up. Okay. Mr. Blackshear, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. So, Mr. Blackshear, as I look at this, I don't see where it says that there are court costs that are involved. Do you understand if I accept your plea that you'll have to pay court costs? Yes,
Your
sir.
Honor, I believe the court costs and the fines are addressed on page 2 or 3,
Good, thank you.
I believe. I can't remember if that's.
Gotcha. Yes, sir. Number 5, 1140, standard court costs. Good, thank you, sir. And you're right, fines after that. Okay, good, thank you. Mr. Blackshear, are you currently under the influence of any drugs, alcohol, or medication?
I'm not, Your Honor.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
I have been, but I'm not.
Okay, are you currently prescribed any medication?
Not at the current moment, not any kind of narcotics or anything, Motrin and stuff through the VA.
Okay. How far did you go in school?
I'm a GED graduate, but I was starting first class, and I was a Green Beret with 7th group. Did 15 and a half years, so I did quite a bit of military education, ranger schools.
Yes, sir. Good, okay. Did you read the plea agreement?
I did, Your Honor.
Do you understand it?
Absolutely.
Did you discuss it with your attorney?
Absolutely.
Did he answer all of your questions?
100%.
Are you satisfied with his representation?
I am.
Did you sign the plea agreement?
I did.
Do you understand that if I accept your plea, that you're waiving your right to trials by jury?
100%.
Do you believe it's in your best interest to enter the plea?
I do.
Are you entering the plea today freely and voluntarily?
Absolutely.
Has anyone forced, threatened, or coerced you into entering the plea?
No, Your Honor.
Has anyone promised you anything other than what's in the written plea agreement?
They have not.
The other side of that, has Mr. Heath or anyone else said, Mr. Blackshear, if you do not enter this plea today, you shall be sentenced to 20 years in prison or any other definite sentence?
This is in my best interest. No, Your Honor.
Mr. Blackshear, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty. In case number 2021 CF 2409, you're sentenced to 60 months with the Department of Corrections. All of these are with credit for all time served, and all of them are to run concurrently, run at the same time. In case number 20 CF 2405, again, and all of them are adjudication of guilt. You're sentenced to 60 months with the Department of Corrections, and that's concurrent with 21 CF 2499. The state dismisses 20 CF 1954, so that case is dismissed. You will be required to submit to blood or swab specimens pursuant to Florida statute. And then all the financials that are in here are imposed. Madam Clerk, do you need those stated out loud, or them being in here is significant or acceptable? Okay. Mr. Blackshear, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
I do, Your Honor.
And we have one other issue, Judge, if this is a good pause to address the court with it.
Yes, sir.
The state and I have agreed to, if the court approves, to put off sentencing until October 19, Judge.
Okay. I thought I just sentenced Mr. Blackshear. Where did it say it was going to be?
It wasn't included in the document, Judge. We were going to address it with the court. If that is improper, then we can certainly add it.
We just wanted to make sure that you had the plea agreement so you knew that this was agreed upon and there was no.
Y'all need to stop me before I start reciting what the sentence is. You need to stop me and say, wait a minute, Judge, don't do that yet. Because once I sentence someone to prison, I lose jurisdiction. So I don't know how that works at this point.
Judge, hold on.
Mr. Kleins is jumping up to help.
Judge, we'd respectfully request to continue the sentencing hearing until October 19th. Continuing today till September, October. Or we
My
can,
concern is that I just said you're adjudicated guilty and you're sentenced to 60 months. I don't know how I undo that.
Judge, we would just move to withdraw the plea until October 19th, and if both parties stipulate to it, I don't see why that would be an issue.
Okay, Mr. Blackshear, knowing that I have some concerns about jurisdiction, but also the confusion between the attorneys and the court, I will postpone your sentence. I do accept the plea, but in the future, the attorneys just really need to flag me early because it puts me in a heck of a bind. And so I do have concerns about that. But as long as you're here, when will Mr. Blackshear be here for sentencing?
October 19th.
Okay, so October 19th at 9 o'clock. If you fail to be here then it would be a plea straight up to the bench. You could be sentenced up to the total of these 50 or 60 years,
It's 104, Your Honor.
okay? 104 years in prison, so it's not worth the downside to you, okay?
Absolutely.
So I'll see you at 9 o'clock then.
Thank you, Your Honor.
Thank you, sir.
Your Honor, appreciate the courtesy. That's all I have before the court this
Thanks,
morning. May
Mr.
be excused. Thank you,
Yes,
Judge.
sir.
I apologize for the confusion, Your Honor. I'll make sure to point that out.
Not a bit. I just want to make sure that we do what everybody intends. Thank you. Okay, Mr. Geisel.
Morning, Your Honor.
Good morning, sir.
Here, on Misty Woodward's case, she's approaching here, Your Honor.
Hello, Ms. Woodward.
And then,
Mr. Gates, it looked funny you coming out of that side door. Yes, sir, Mr. Geisel.
yes, can we approach?
Yes, sir.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m.
Thank you. So, Ms. Woodward, we had discussions when you weren't here before, and so that's what we were following up on. The discussions at the bench were consistent with that. So I will continue your case until November 13th at 9 o'clock. Make sure that you stay in touch with Mr. Geisel, okay?
Yes, sir.
And I'll see you then.
Thank you.
Thank you, ma'am.
Thank you,
Mr.
Your
Geisel.
Honor. God bless you.
Thank you, sir. Mr. Gates. You just like being back there, Mr. Gates.
Not as much as you might think.
Yes, sir, Mr. Gates.
Your Honor, this is Julio Ramos. It's going to be in both cases, as the court was made aware previously. I represent him on one case, and the other one he was pro se, but I'll file a notice of appearance on the second one, and the written plea that Ms. Davis is signing right now reflects both cases.
Thank you.
May I approach?
Yes, sir.
Judge, I'll have to update the score sheet to reflect the changes in the charges. As such, I just want to make sure
Meaning
that.
amending the information?
No, Judge.
So lesser included?
Yes, Judge.
Oh, okay, good.
So, but I'm going to make sure that we have on the record that the defense stipulates to the priors in the previously provided score sheet.
Mr.
We do,
Gates?
Your Honor.
Okay.
And there's two case numbers, Your Honor, in 1040, 23 CF 1040, we're going to withdraw our previously entered not guilty plea and enter a plea to count 2 and 3. Count 1 is going to be dismissed by the state. In the other case, it's a 3-count information, 1's a felony and 2 misdemeanors. We're entering a plea of no contest in that case. The understanding that it will be a 3 3-year probation sentence with the terms and conditions outlined on the plea agreement, and the court costs are reflected in paragraph 5 of the plea agreement.
Thank you. Mr. Ramos Perez, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Yes, ma'am.
There are a couple of misdemeanors, so the state would propose to adjudicate and credit for time served on those.
No objection.
Mr. Ramos, did you read the plea agreement?
Yes, sir.
Do you understand?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
No.
Did he answer all of your questions?
Yeah, yes.
Okay, do you have any questions of him or the court or the state?
No, sir.
Do you understand the plea agreement?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Ramos Perez, do you want Mr. Gates to represent you on the second case, which is 23 CF 1479? Do you want him to represent you on both cases?
Yeah.
Okay, good. Any questions, Mr. Ramos, about anything? You were slow in responding. I just want to make sure did you understand everything that's in the written plea agreement?
Yes, sir.
Okay. Mr. Ramos Perez, I do accept your plea. You're adjudicated guilty of the misdemeanors and you're sentenced to time served. On the felony counts, you're sentenced, it's withhold of adjudication. Well, you've gotten rid of one of the blank lines. It is a withhold, correct?
Yes, it is.
Okay. In the form, one of the 3 lines. No, you're fine. Mr. Ramos, your adjudication has withheld on the felony counts. You're sentenced to 3 years probation. That will run concurrently, run at the same time. 23 CF 1040 is, count 1 in that is dismissed. You'll need to submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. You'll need to submit to random urinalysis, not have any medication, any drugs without a valid prescription, perform 24 hours of community service work, and you can pay that off. Anything that I missed for Mr. Ramos Perez?
No, sir, I'd just like to state on the record, he does have a valid medical marijuana.
Okay. Thank you, Mr. Ramos Perez.
Thank
Good luck
you,
to you,
sir.
sir. Okay. Mr. Madden. Morning, sir.
Good morning, sir. John Madden here on behalf of Mr. Salazano. It's 23 CF 877. If the court recalls, we were here last time. I had requested a continuance since I was having issues communicating with my client. Judge wanted me and the client to be here. We've reached out to my client and have had no response, so that's why he is not here today.
What does the state seek?
We would request a capias, Your Honor.
A no bond capias will be issued for, and how does he pronounce his last name?
I believe it's Solozano.
Okay, Mr. Solozano. So when they find him and arrest him, then they'll bring him to first appearance, and then we'll set another hearing.
Understood, Your Honor.
Thank you, sir.
Thank you, Judge. That's
Good
all I
seeing you.
have.
Yes, sir. Mr. Lopello. Good morning, sir.
Good morning, Your Honor. Sean Lapella for the record, for Alan Muller, 21 CF 730. Mr. Muller present for the court. This case is set for trial. We requested the second week, week of the October 2nd. And I have a couple updates for the court for the record, and then we can talk about scheduling and how many jurors we need.
Okay.
I would like to inform the court that we have filed a notice of reciprocal discovery regarding a witness that came to our attention through another witness that we had doing our trial prep. This witness disclosed another witness that we feel is relevant to the case. We provided the contact information for this witness to the state as of yesterday. It wasn't a delay on our part, intentional. at all, and I believe Mr. Gomez is aware of that witness, so he's on notice of that. Secondly, we filed a motion in limine regarding a few issues in the case. I don't know when the court wants to set a hearing for that, preferably before jury selection, obviously. And then we also filed a motion to dismiss. We found a flaw in the information that we anticipated would be a trial issue, but however, after reviewing jury instructions and preparing, we feel it is necessary to raise the issue. It's about a defect in the information in order to avoid jury confusion and whatnot. So we filed that motion to dismiss. So we'd like to have that heard, preferably perhaps next week or something like that. As far as jurors go, I think we're going to need a minimum of 50. This is charged as a hate crime, even though we dispute that it is. And so we're going to need a lot of jurors because there's going to be a lot of issues there. There's also self-defense, stand your ground issues, which may also exclude a lot of jurors. So we anticipate at least 50 are necessary to accomplish the selection. And we're going to also be asking the court, we haven't filed a motion to this extent yet, but as far as that witness goes, named Shane Wiley, he's out of Virginia, he's military. So we're going to be asking the court to have him appear by Zoom. We can file a formal motion in that regard. I believe the state wants to object to that, his appearance by Zoom. So those are the issues that we have for the court on this issue, on this particular case.
Okay. Yes, sir.
Your Honor, I think that the state's ready for trial. We would request probably trying to hear, if possible, I don't know what the trial schedule is looking like the first week, but if we could potentially hear any motion hearings on the motion, limiting the motion to dismiss on the Friday of the first jury, or of the first trial week on that Friday. That would be when the state would be open to hearing those motions, so that way we can make sure it continues to track for the second week of trial. We would also request that any motions in limine, or any motions, pre-trial motions, be filed before tomorrow at 5 p.m. So that they can be heard the following Friday that week. Give us a week to prepare, or give defense a week to prepare for any motions in limine that we may file, and then have all of the hearings on that Friday before the second trial week, and then be ready for trial on that second trial week.
Okay. Any objection to the cutoff for filing motions at the end of the day tomorrow?
I think we filed ours already, Judge. So if the state's going to file some, we'd ask that they be filed as soon as possible.
Okay, so you agree both sides has a cutoff tomorrow at 5?
Unless the status quo changes, Judge, I'm not going to stipulate. What if there's an issue regarding a last minute alteration, if something changes between now and then, or based on court's ruling in the interim, we may file an emergency motion for some reason, but it would be obviously be in good faith. So, but I understand the court's prescription on this issue. Thank you.
What about 50 on the Venari?
That's a good number with the state, Your Honor.
Okay. In the state, you know better about scheduling of trials next week and the week after that?
The second week, we're looking at going on Monday and Tuesday based on my discussions with other ASAs about their trial scheduling. So it would be the Monday and Tuesday of the second week.
Would be,
I believe it's going to be October.
Mr. Mueller's case?
Yes, Your Honor. It would be October. Yep.
October 2nd.
I don't anticipate we'll be able to try the case in 2 days, Judge, especially if the state's anticipating trying another case that same week and picking a jury that same day, that Monday. If we pick 2 juries on Monday.
Well, we don't have to do that anymore. We don't have to pick all the juries on Monday. That's one of the good things that came out of Zoom, is we can pick juries every day and do pick and goes every day if you wanted to. So
well,
if
Judge,
you pick the jury on Tuesday.
I anticipate the jury selection is going to take quite a bit of time. I think reasonably we'd expect to have the jury selected by maybe 2 o'clock or so the first day, just because of the amount of questions that are going to have to be asked about issues regarding hate crime and racial tension and bias and all that.
So you think it's going to take 3 days to try?
I think it may bleed over into a third day, especially if we get through, it depends on, if we're only going to go to 5 o'clock, theoretically, it could bleed over into a third day, especially if we're looking at issues with jury instructions, certain defenses that may be applicable, which we'll try to get resolved as much as we can ahead of time. But in these types of cases, it's difficult to know what's going to come out in evidence and what the court's going to approve as far as some of these issues. So I anticipate a lengthy charge conference and long closings, and anticipate it could bleed into a third day. I just don't want to preclude the possibility it could bleed into a third day.
Judge, I hate to speak out of turn. I just know that court is going to be trying to fit several jury trials together. I know that Ms. Davis has a hard setting for Friday of that second week. My trial with Mr. Nopes and Ms. Merrifield, it sounds like, based on conflicts in their schedule, they won't be able to go first week. So we were looking at Wednesday and Thursday with the understanding this was going to be a 2-day trial. I understand the court is dealing with a number of cases. I just wanted to get my word in.
Good. No, I appreciate it. So what about going on Mr. Miller's case next week?
I can't because of witness availability. There's multiple officers who are no longer with OCSO that we're having to bring in just based on their involvement with the case, and so that second week for us is kind of where.
And to the state, you're the only one that knows the whole picture. The defense attorneys don't, the court doesn't. You're going to have to choose how you're going to work things. I can't fit a 3-day trial into a 2-day period. So y'all have got to tell me how you want to do it.
I'm flying in a witness from out of state, so I don't have a choice. But
What day?
for Friday.
Okay, so that's 2 weeks from tomorrow?
Yes,
Friday?
Judge.
Okay, and
The
what is
5th,
that case?
That is going to be Joel Walls with Mr. McKinney.
Okay, so, and is it going just Friday or is it going to be 2 days?
No, it's just a 1 day.
So that would be a pick and go?
Yeah.
Okay, so Walls, so that's the 5th, Madam Clerk, is that right? 6th, okay. Did I miss a day? I thought you said that Tuesday was the 6th. Thank you. Thank you, ma'am. Okay. To the state, what else do you have locked in as far as witnesses and those things?
I have to go on Tuesday for Mr. Vordenbaum, this coming Tuesday for Mr. Vordenbaum's case. Driver license suspended.
1 day?
Yes, Judge.
Okay.
And Your Honor, I believe I have Toriana Marsh that's going to be going that first week as well. That would be a 1-day trial. We can go.
You have a day that you're...
Was there a date that we?
Thursday.
The Thursday, the 28th, Your Honor.
March, okay. Okay, and then what is the case that conflicts with Mr. Mueller's going on Wednesday, August 4th?
Judge, that's Javier Savio.
And is it going to be just that 1 day?
No, Judge, it will be Wednesday and Thursday. We were anticipating morning jury selection, diving right into openings and testimony after that.
Okay. Again,
Your Honor,
yes, sir.
in this situation, given that there's a motion to dismiss filed, we have, I know that Savio has been continued for trial with the last 2 cycles, and I know he's ready to go. So I don't necessarily have an issue with continuing this to the next trial cycle so that we iron out the motion to dismiss any of that. I would just want it to be hard set on that next trial cycle if that's what we're going to do. But I mean, the state's ready. We're ready to go this cycle if we can. But I understand the toughness. It's just with there was a lot of witnesses. There's multiple law enforcement officers that pulled surveillance video, or they did a photo array, or a variety of different things that are now out of county, and so this first week wasn't really available for the majority of my witnesses on this case.
Okay. I just thought about, I talked to Judge Ketchel in the hall a couple days ago and said, you going to have any time open? He said he wasn't going to have any time open next week, but that he may have 2 days open the next week after that. What if Judge Ketchel tries Sabio?
I'll leave that to Mr. Rogers and Mr. Nobes.
We're not in agreement with that.
Okay,
The state has no problem with that.
I don't know how you can say no to that, but I thought I'd ask you. But logistically, the same people that are trying Sabio are not trying any other case at that same time.
No, Judge, Wednesday and Thursday is open. I've confirmed, at least with my law enforcement witnesses, they're good to go Wednesday and Thursday. So,
Okay. So I'm going to schedule Mr. Mueller's case for Monday, October 2nd, unless the state wants to change that. On Mueller on October 2nd, 3rd, and 4th.
Motion's on the 29th, Your Honor.
But I sure need to make sure that Judge Ketchel's available for those other 2 days. I'm sorry, yes, sir?
And motion's on the 29th?
Motion's
there-
on the Friday,
there-
the 29th,
At what time?
9 o'clock.
And
So I will hopefully know from Judge Ketchel for sure. He said 2 days. I don't think he had it locked in on which exact 2 days that was. In other words, I think that from what I gathered from him, he had some flexibility on that. So if something goes horribly wrong and Judge Ketchel can't do Sabio on Wednesday and Thursday, then it sounds like that the state wants to continue Mueller, and then I would try Sabio. Is that accurate?
That sounds accurate, Your Honor.
Okay.
And on the issue of our witness, or tennis motion to appear by Zoom, I think the state's going to object to that. Is that correct, Mr. Gomez?
That's correct, Your Honor.
So you're going to have to file that
a
motion, and I'll hear that on Friday, a week from tomorrow also. And that date is what?
9/29.
29. Thank you.
I
Yes,
believe
sir.
that covers all the bases, Judge. Thank you.
Okay, good. Thank you. So I'll see you back here next Friday at 9 o'clock. Okay. Good.
Thank you, Your Honor.
Ms. Simon?
Good morning.
Good morning. And Ms. Simon, if you'll just give me a moment, let me see if I can email Judge Ketchel and see if that's going to work. Okay.
October 16th. It's Monday. Or no.
Let's do the 19th, because I have court on the walls on the 16th.
That works.
Is that 9?
Okay, good. Yes, ma'am. Ms. Simon?
Good morning. Kelly Simon on behalf of Ronnie Lozano Amador, 2023 CF 985. This was a control date basically to make sure that Mr. Lozano Amador was in pretrial intervention. I am waiting on the paperwork from Mr. Gomez. We had scheduled this just a week out from last week. We need a little bit more time to make all that happen. We have agreed to pass this for 30 days. If we could reset it for October 19th at 9 a.m. to make sure that Mr. Lozano Amador has signed the appropriate paperwork and gotten into pretrial PTI.
Yes. Okay, any objection from the state?
No objection, Your Honor.
Okay, so you want to continue it one cycle? Or what do
We
you?
just want to set it to the 10/19 October date. We
10/19.
anticipate
Good.
it falling off the docket before then, but we just wanted to hold it there.
Okay, so.
And I will
unless you-
say, I'm not sure that he understands much English. We have limited communication. I did not have an interpreter this morning. But forewarning you before you speak to Mr. Lozano.
Mr. Amador, I'll see you back here on October 19th. Okay, do you know when that is?
No.
Okay, I'll see you then at 9 o'clock.
Thank you.
Unless the paperwork is signed and Ms. Simon says you don't need to be here. Okay, good. Thank you, sir. Thank you.
That's all I have this morning.
Thanks, Ms. Simon.
Thank you.
Ms. Merrifield.
Morning,
Morning, ma'am.
Brandy Merrifield on behalf of Toriano Marsh.
Oh, Mr.
and
Marsh.
22 CF 2119. And Judge, we are here today ready for trial. After discussing it with the state, I believe that the 28th of September was the date that would fit in everybody's schedule.
Okay, and it'll be a one-day?
Believe so, Judge.
Yes, Your Honor, that's correct. And just for the court and the defendant's awareness, at this time, the state would revoke its offer in which we dismissed 1 count of the aggravated assault, and we will be moving forward to trial on 2 counts of aggravated assault with a deadly weapon.
Okay. Mr. Marsh, do you understand the state is going to withdraw that offer if you don't accept it today?
Yes, sir.
Okay. Have any questions for me or your attorney or the state about that?
No, sir.
Okay. Still wish to go to trial?
Yes, sir.
Okay. So we'll go to trial on September 28th. We'll start at 8:30. How many will you need on the venire?
Just the standard, Judge. I don't anticipate needing a larger venire.
That's correct, Your Honor.
22?
Yes, Your Honor.
Okay. Okay, if I can get jury instructions, when do y'all think you can get those to me?
Can we do would Tuesday
End of the day,
after-
Tuesday?
Tuesday afternoon? Yes,
That'd be
Your Honor.
great.
That would be my preference.
Good, okay.
Would that be close of business Tuesday, Judge? Or?
Yes, ma'am. If you
Thank
can do it then I'll do my homework, and then we'll talk about that. As you both know, and Mr. Marsh, the attorneys know that's one of my pet peeves, is the jury or the venire, the group from which the jury selected, waiting on us on things that we could have done before. So that's why I start talking about jury instructions really early, okay? So
I would
jury
also-
instructions and also proposed verdict form.
I would also ask, Your Honor, and I don't anticipate there's going to be anything too crazy, but any motions also be filed by tomorrow at 5 p.m. on
I would
this as
agree with
well.
that, Judge.
Okay, good, thank you. So, Mr. Marsh, I'll see you on September 28th at 8:30. Okay, thank you, sir.
Thank you, Your Honor.
Thanks, Ms. Merrifield. Mr. Nopes?
Good morning, Your Honor. I've got Javier Savio.
Hello, Mr. Salvio.
Good morning.
Good morning.
Judge, I know that the state's filed some motion in limines. I've filed some motions as well. If we could have the same Friday date, the 29th, and I would need it to be 10 o'clock or later. I've got 3 depots starting at 9 at the state attorney's office here on 2 other criminal cases.
Okay, do we want to do them at 1:30?
I'm fine with that. That work?
Just to be clear, I'm sorry, we're talking about addressing the motions in limine on Friday the 29th?
Correct.
That's fine with the state, Judge.
And also jury instructions then, too?
So actually, we've already, we've submitted jury instructions to Your Honor previously. I don't intend to change them, and I would imagine the objections from the defense are the same. So I think we can probably address those on Friday as well.
Okay. 29th, I was just thinking the motions in the morning sound like they're going to be pretty long, so let's do the 29th at 1:30.
That'll be fine.
And it's going to trial
Come and see you next week.
on October 4th and October 5th, correct?
That's correct. Yep.
Okay. I just got back an email from the JA. Judge Mitchell may have had it backwards. Because she says he's got a civil jury trial that week. I thought he said he had next week civil trials and not any the week after. Okay.
Hmm?
Well, again, our default is that Sabio will go and Mueller won't.
Just, I'm going to speak, if possible, with Mr. Kleins. If in that instance, Mueller can't go because we need 3 days, I would request to put in McLean on that Monday. So the idea would be to do McLean on Monday, and that way we're not losing any sort of days or whatever. Because that was a trial that I didn't necessarily anticipate occurring, but it is going to occur this cycle, and so I would be completely okay with moving that into that Monday. And that's
Okay.
it.
Okay, let's finish up with Mr. Sabio, and then we'll talk about that. Good, thank you. Okay, so on Mr. Sabio's case, I will see him a week from tomorrow at 1:30. We'll have all the motions, talk about any preliminary things, and then we start on Wednesday, October 4th at 8:30, and we'll bring in the venari and pick the jury.
I was just going to say, just so we're clear, I think both myself and Mr. Noakes anticipate taking the jury and diving straight into opening some evidence.
Good, okay. How many on the venari for Mr. Sabio?
The only real hot button issue is alleged violence. I'm fine with 30.
Yeah, I'm fine.
Okay, 30. Mr. Sabio, I'll see you a week from tomorrow, okay?
Yes, sir.
Thank you, sir.
Thank you, Judge.
Thanks, Mr. Noakes.
That's all for me. if I may.
Yes, sir. Thanks, Mr. Rudd. Okay. Any other private counsel that are ready? Let me get back to where I can see Zoom. I have Mr. Stone on. Mr. Koch?
Yes, I'm here.
You want to take Mr. Stone's case?
Yes, sir. Good morning.
Good morning, sir.
Good morning.
Your Honor, this will be a change of plea, no contest, as charged. There'll be adjudication of guilt, credit for time served. There'll be $515 for court costs, $150 for defense costs. This case has a cost of investigation of $60.51. And there's also reimbursement of prisoner transport that totals $262.01, Your Honor.
Okay, and how long is your client going to need to pay those?
Your Honor, if we could get 6 months, please.
Okay. Mr. Stone, if you'll raise your right hand. Do you
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. So, Mr. Stone, did you understand everything that Mr. Koch stated today?
Yes, sir, I did, Your Honor.
Okay. Do you understand that you're waiving your right to a trial by jury?
Yes, sir, Your Honor.
Do you have any questions for the court or your attorney?
No, sir, Your Honor.
Mr. Stone, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for... Let me ask you this, Mr. Stone. Have you ever been adjudicated guilty of a felony before?
Yes, sir.
Okay. I do accept your plea, Mr. Stone. You're adjudicated guilty. You're sentenced to credit for time served. You'll need to pay the court cost, $150 public defender's fee, cost of investigation, $60.51, cost of transportation, $262.01. And if you fail to pay those within 6 months, then they will go to a civil lien or judgment, okay?
Okay.
Thank you,
Yes,
Mr.
sir.
Stone. Thank you, sir.
Yes, sir. Thank you.
Okay, Mr. Koch, who else do you have?
Your Honor, I have Ms. Ramirez, who's present in the galley. This is 2023 CF 622, who's present approaching.
Good, thank you. Hello, Ms. Ramirez. Good morning. Good morning.
Judge, the defense is ready to move forward trial. We did have a witness that we added during pre-trial, and I know that state may be requesting a defense, or a continuance, Judge.
Judge, we're going to request a deposition with the witness that was disclosed that we didn't know about until the morning of pretrial. So it will be a trial next cycle. We have no question with that.
Okay. Ramirez, do you agree to the continuance?
Yes, sir.
Okay. I'll see you back here on November 13th at 9 o'clock, okay?
All right,
Thank you, ma'am. Mr. Cobb?
Your Honor, that's everyone I have that's not in custody.
Okay, thank you.
Thanks, Judge.
Let me make sure I don't have any pro se's. Okay, thank you. Okay, then to the PD, folks that are not in custody.
Your Honor, I have Derek McLean.
Mr. McLean is present and approaching, Your Honor. We remain ready for trial. I would, hearing all the discussion about the various trials that are being set, I would just remind the court, Mr. McLean did ask the court for continuance on Monday to seek private counsel. He's related that one of them has not returned his phone call and the other one was out of town. So we remain ready to proceed, Your Honor, but given the tumultuous trial schedule, certainly Mr. McLean would be receptive to a continuance so he can continue to try to hire private counsel. But if not, we can proceed the second trial week.
And I haven't gotten a second email back from Judge Ketchel or his JA. So I don't know if he's going to be able to cover, it sounds like he's not going to be able to cover anything that second week. Is the state able to try Mr. McLean the first week?
We could, Your Honor. I do have a trial that's currently set on that Thursday. And so
Right.
I am running into a little bit of concerns on if we end up going on Mueller and Judge Ketchel is able to cover those dates, it would be tough for me to squeeze because we don't have Monday. Because if we had Monday, then I would say let's go on Monday or Tuesday and then give me like a day to prep for the second trial. But I mean, if this court is inclined, I'll do what I need to do. If you want to set it on that first week, I don't have an issue.
So the only day you've got open, I think, is Wednesday, the 27th, right? Because you've got Vordenbaum on Tuesday, Marsh on Thursday, and then the motion hearings on Friday.
That's correct, Your Honor. Yes, Your Honor, we can put it on that Wednesday, and I'll figure it out.
On the 27th? Okay, so it's,
I mean, to be quite frank, Your Honor, I want to wait and get an answer from Judge Ketchel, because if I can move that McLean trial to the second week, I would much rather prefer to try it that second week, just with how stacked the first week is.
understand. So you're hoping for Mr. McLean to go on October 2nd, the Monday?
I think it would actually end up being the Tuesday, because if
Tuesday.
I'm not mistaken, Mr. Klein's has to be at a deposition on Monday.
That's correct, Your Honor.
Okay. Understand. Mr. McLean, I hate to keep you on the bubble, but I'm going to schedule you for October 3rd at 8:30 in the event that Mueller cannot go, the case before you can't go. How many will you need on the Venari? Is it a one-day trial?
One-day trial, Your Honor, 22 is fine with the state.
I would agree to the 22. There is going to be 2 defense witnesses at least, if not 3. So I think we can get it done in a day. I mean, this isn't the most complicated fact pattern in the world, but it might be a long day.
Okay. So right now, Mr. McLean, I'll see you back here on Tuesday, October 3rd at 8:30. Stay in touch with Mr. Klein's. If that can't happen, then I'll let Mr. Klein's know I'm going to nail down Judge Ketchel today. I tried to do that in the last couple days, and it didn't work very well. He'll let you know at the end of, or he'll know by the end of today.
And I will let you know. I'll be here all day. So.
And if it doesn't go on Tuesday, October 3rd, then your case will be continued until November 13th, and we start the process over again. We'll be looking at going to trial at the end of November.
Yes, sir.
Okay?
I'll call you before the end of today. Okay. That's all I got out of this.
Yes, sir.
Good morning, Judge.
Good morning, sir.
I have Vincent Rump. Mr. Rump is present and approaching 23 CF 352.
Hello, Mr. Rump.
How are you doing, sir?
Good, how are you?
Judge, this is on the trial docket. We remain ready for trial.
Okay, on Mr. Rump's case?
Judge, we have reached out trying to get a hold of the victim in the case. I don't believe she is present here today as well, Your Honor. So at this point, the state's going to have to announce a no clause.
Okay. Mr. Rump, your case number 23 CF 352 is dismissed. Thank you, sir.
Have a good day. David Taylor.
Hello, Mr. Taylor. Good morning.
Judge, this is Mr. David Taylor before the court in 22 CF 2917. This is not on the trial docket. This is for entry of a plea. Mr. Taylor is going to be entering a plea as charged for an adjudication of guilt, 10 months in the Okaloosa County Jail with credit for all time served. That credit is specifically to include 10 months in the Escambia County Jail from case number 17-22 CF 4159. The intention of the parties is a time-served agreement here, but written in a way that it is 10 months with credit for 10 months that he has served in another jurisdiction. $515 in court cost, $150 cost of defense. Mr. Taylor would ask for 6 months to pay off those amounts. May I approach with the plea agreement?
Yes, sir. Mr. Taylor, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Mr. Taylor, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Taylor, I do accept your plea. You're adjudicated guilty. You're sentenced to 10 months in the Okaloosa County Jail with credit for all time served, including the time that you spent in the Escambia County Jail in 17 CF 4159, so you don't have to serve any additional time. You'll need to pay the court costs, $150. If you fail to pay that within 6 months from today, it will go to a civil lien or judgment.
Yes, sir.
Thank you, sir.
You're going to go over there for fingerprints. Joe Walls.
Thank you.
Mr. Walls is present and approaching in 21 CF 1796.
Hello, Mr. Walls.
Judge, and the court has heard in the scheduling discussion that Mr. Walls is going to be scheduled for October 6th for a pick and go.
Yes, sir.
I do agree with that date. I believe that that is appropriate, and I believe that we can try the case as a pick and go. I believe that the state's witness flying in from out of town is dictating that we go on that day.
Okay. How many will you need for the venire?
I think 22 would be sufficient.
To the state? 22?
Yes, Judge, my only hesitation is the trafficking. I know we've had a little bit of issues with those kind of cases.
Do you want 30?
I would say 30 just to be safe.
Okay.
I think that's fair.
So when can you get me your jury instructions?
Priority has been getting Mr. Bordenbaum's done because that's going to be this coming Tuesday. My anticipation is probably by the end of next week, I'll have your instructions on Mr. Walls' case.
That would be great. So, Mr. Walls, I'll see you back here on October 6th at 8:30, okay? I get everybody here about 30 minutes before the venire is ready to see if there's anything we need to do before we bring them up around 9, okay? So 8:30 here, 2 weeks from tomorrow. Okay.
And Judge, just to be redundant for Mr. Walls, we would be picking the jury on the morning of the 6th, and then as soon as we're done picking the jury, we would roll right into testimony into the trial, and we would have the trial on the same day.
So we're going to be here all day on that Friday. Okay. Good. Thanks, Mr. Walls.
Robert Zollner. Mr. Zollner is present and approaching in 23 CF 721. Judge, this is on the trial docket. However, there has been an agreement between the parties, and that would result in a PTI.
Good.
The PTI would include terms of 10 months of PTI supervision, substance abuse evaluation, no violent contact with the alleged victim, and there would be an automatic early termination clause. So as soon as he's complete with his substance abuse evaluation and recommended treatment, that's all.
then his case will be dismissed, right?
Yes, Judge.
Good.
So given that there's not really much downside to Mr. Zollner, we would be in agreement with that result.
Okay. Mr. Zollner, heck of a shift. I go from coming on the bench with a note that says jury trial and then to pretrial intervention. So that's really good. So yes, ma'am.
Judge, just to make sure the record's clear, this is consistent with the victim's wishes in the case.
Good. Okay.
So Judge, procedurally, I guess I would request a continuance until
Yes.
the 13th November as a status date, but I believe that this will roll off as soon as we're able to complete the paperwork, and we will endeavor to do so quickly.
Okay. Mr. Zollner, if you're not accepted into pretrial intervention before November 13th, I'll see you back here November 13th at 9, but I wish you the best in that. At the end of all that discussion that Mr. McKinney had, it said, if you do everything, then your case is dismissed. You don't have to worry about me anymore. Okay?
Thank you, Judge.
Thank you, sir. Good luck to you.
Will do. Judge, that's all I had that are out of custody.
Okay.
Your Honor, I have somebody on the afternoon docket who's here. It's William Becker. I'm sorry, I'm looking at the files. Mr. Becker is present, Your Honor. I believe the state's going to have an announcement on Mr. Becker's cases.
Yes, Your Honor. At this time, the state's going to announce a dismissal of the VOP, revoke and terminate just to terminate the supervision and convert any outstanding costs to collections. I believe it's just court costs that's outstanding.
Okay. So you said outstanding court costs to collections?
To collections, Your Honor.
Okay.
It's going to cost you. Your Honor, Mr. Becker would just ask the court to give him 9 months to try to make the payments before it gets reduced to collections.
Okay. Mr. Becker, I don't see any downside to that. Your violations of probation are dismissed. All outstanding financials will go to a civil lien or judgment 9 months from today if you fail to pay them, okay?
Awesome, thank you.
Thank you, sir.
And Madam Clerk,
Supervision is revoked and terminated.
this is also going to include the 22 MM 44 and 50 cases. Okay, just want to make sure.
Okay, the folks in the gallery then, the folks,
There's several that have private attorneys that are not present.
okay? For those of you that are waiting for private counsel, we'll wait as long as we can, okay? Yes, sir. Mr. LeBeau.
I've been informed that the attorneys that are not here are in Walton County, I believe.
Okay.
Judge Wells has the docket. And I'd like to approach on Mr. Muller's case with the state just briefly.
Okay. Yes, sir.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
This house that you're closing, what county? What county? Is it in Walton County? Okay, probation was just asking.
Yeah.
Your Honor, this is Mr. McGaw on 22 CF 2992. We have reached an agreement to resolve this case. At this time, Mr. McGaw would be entering a no contest plea to the lesser included offense of felony battery. I'm going to announce all of this. Yeah. The agreed upon disposition is he'll be placed on 2 years of probation. This will terminate automatically at 9 months if all of the special conditions of supervision are completed. These special conditions are that Mr. McGaw will attend and complete an anger management course,
He will have no contact with Christopher Davis. He will pay $2,500 restitution to Christopher Davis, $967 in court costs, a $50 application fee, a $100 public defender fee, and there would be a withhold of adjudication. May I approach?
Yes, sir.
You have the score sheet, right, Scott? And Your Honor, just for the record, this plea agreement was presented to the defendant at the request of the victim. The state spoke with the victim, and he specifically requested a probationary sentence with anger management and to pay restitution, which is why we presented the offer to the defendant. So.
Okay, good, thank you. Mr. McGaw, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
so
sir.
help you God.
Yes, sir.
Thank you, sir. You can put your hand down. Mr. McGaw, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yeah. Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. McGaw, I do accept your plea. Adjudication is withheld. You're sentenced to 2 years probation. Your supervision will automatically terminate at the 9-month mark if you've successfully completed all the terms of your supervision and haven't committed any new law violations. You'll need to enter and successfully complete the anger management class, have no contact with the victim, pay restitution of $2,500, pay the court costs, $150 public defender's fee.
And, Your Honor, I talked with probation. Mr. McGaw is actually in custody right now for a county jail sentence that is going to schedule to conclude on September 28th. On that date, he is actually closing on a house in Ponce de Leon.
Yeah.
Not sure if it's the Walton County or the Washington County Ponce de Leon, but somewhere over there. And so Mr. McGaw is going to request that the court authorize him to appear in the probation office by the close of business on that day. He's going to essentially be released and go straight to the closing and then come back here to probation.
Yeah.
So by the end of the day, which day?
September 28th.
Okay, yes, sir, that's granted.
Thank you.
Okay. Probation.
He needs to be there no later than 4 o'clock, so we have time to do the paperwork.
You going to be able to be there by 4?
Yes, sir.
Okay, yes, sir. Thank you.
Thank
Thanks,
you.
probation.
Thank you.
Thank you. Oh, Mr. Hutton.
Morning again, Judge.
Good morning, sir.
This would be a change of plea. I have Mr. Perone standing to the left of me, Your Honor. This would be enter a plea of no contest. To count 1, he'll be 11 months, 29 days, Osceola County Jail. Credit for...
Osceola or how about Okaloosa?
I apologize, Judge. Okaloosa.
Yes, sir.
Coming from a different circuit, I apologize. Credit for time served be $515 in court costs, $150 for the defense costs, Your Honor. Be order and reserve restitution for 90 days. And in count 2, be adjudicated guilty, and then credit for time served. If I may approach people.
Yes, sir. Thank you.
And the state will provide a score sheet at a later date, Your Honor, or later this afternoon.
Okay, thank you. Mr. Brown, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Perone, did you read the plea agreement?
I did, sir.
Do you understand it?
I do, sir.
Did you discuss it with your attorney?
I did, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
I am.
Did you sign the plea agreement?
I did, sir.
Mr. Perone, I do accept your plea. You're adjudicated guilty in both counts. You're sentenced to time served in count 2, sentenced to 11 months, 29 days in the Okaloosa County Jail in count 1 with credit for all time served. You'll need to pay the court costs, $150 public defender's fee. If you fail to pay those amounts within, no, I'm sorry, you just need to pay those. Yeah. How long does Mr. Perone need to pay those amounts?
Your Honor, could we get 6 months?
Okay. Yes, sir. So, Mr. Perone, if you fail to pay those amounts within 6 months, they will go to a civil lien or judgment. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution if the state files a motion or a petition within 90 days from today.
Yes, sir.
Thank you, sir. Good luck to you.
Thank you, sir. Thank you, sir.
Yes, sir.
Appreciate it.
Mr. Swain, how are you? Good.
Judge, this is Mr. Antonio Swain before the court, and the operative case here is 22 CF 1589. That's the case that's set on the trial docket. We have filed reciprocal discovery with 2 defense witnesses. After Mr. Swain gave me some information for those witnesses 4 days ago, and we talked about it at docket day. I didn't have time to use an investigator. I went and knocked on doors myself. So I did get the information that we needed for the witnesses. I provided that to the state in reciprocal. It is 2 defense witnesses that are at the same address. The state immediately scheduled those for depositions next week on the 27th. So procedurally, that's where we're at. Mr. Swain, understanding that this case is set for trial, asked for a continuance at pretrial and asked for a continuance at docket day. My client is continuing his request for a continuance so that we can nail down everything we need to related to the defense witnesses.
Okay, to the state?
Judge, at this point, we would ask the continuance to be charged to the defense.
Okay. And that's what we're asking for, Judge.
Mr. Swain, do you agree to the continuance?
Yes, sir.
Okay. Then I'll see you back here no later than November 13th. Yes, ma'am.
I do want to make clear that no matter if Mr. Swain has new trial counsel for the next cycle, we will be requesting trial next cycle.
Okay. So, Mr. Swain, I'll see you on November 13th. I'll be looking at going to trial on November 27th or December 4th, okay?
Yes, sir.
Thank you, sir.
Michael Wilson.
Thank you.
Judge, this is Michael Wilson before the court in 2 cases, 21 CF 863 and 21 CF 3246. Each of these are felony violations of probation, not on the trial docket. We'd set it today in an effort to try to resolve these since we resolved the underlying case. It was set for trial. Quite frankly, we haven't got there yet because we haven't had time with everything else. I'm going to ask for this to be reset for the next miscellaneous, which is October 9th at 9 a.m. without subpoenas.
Okay. So, Mr. Wilson, I'll see you on October 9th, okay? Thank you, sir.
Thank you, Judge.
That's all that is this morning.
Okay. Then the folks in the gallery that are pro se, let's see, I've got 2. One of those is Ramos Perez. Is he off? Okay, so that was done. Then we have William Vordenbaum, correct? Okay. Mr. Vordenbaum, come on up. Okay. Yes, sir. Anything for the court to see?
Just a motion to amend the motion to suppress.
Okay, if I can get a copy, please. Do you have an extra copy? You need that one?
No, I gave her one. I got one. Thank you. I guess the request the evidentiary hearing.
Okay, Mr. Vordenbaum, first off, the appellate courts tell the trial court that at every significant stage of the trial or litigation that we should ask you basically a lot of questions.
Sure.
And did I ask you those before?
No.
Okay.
Yeah. Have you had a chance to watch the video?
I have not. When was that filed with the clerk?
Yes.
What video?
She gave it to me.
Who's she?
I mean, the state attorney gave me the video.
No, sir, I haven't. I don't look at evidence unless, unless there's some motion that I know that I need to do.
Okay, well, I'm going to make a motion for you to watch the video. I mean,
let's wait and make sure that you want to represent yourself, and then you can do that.
Sure.
If you want to.
Yeah, I got you. Yeah.
Okay, so here are some questions. If you'll first off raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can put your hand down. So, Mr. Vordenbaum, do you understand that you have the right to an attorney?
I do.
If you cannot afford to hire an attorney, one will be appointed for you. The state of Florida will pay for a lawyer to represent you, in this proceeding if you qualify? Do you want me to appoint an attorney if you qualify?
I do not.
Let me tell you some of the advantages of having an attorney. Prior to trial, a lawyer's legal knowledge and experience may assist you in attempting to set a bond, but you really don't need that. A lawyer may obtain information about the case through skillful use of discovery. A lawyer may discover possible violations of constitutional rights and take the proper steps to address them. A lawyer may make sure the speedy trial rules and statute of limitations are enforced. A lawyer may identify and obtain favorable evidence to introduce at trial on your behalf. A lawyer can, if appropriate, file motions to exclude evidence, to suppress evidence, and to dismiss or reduce charges against you. Do you wish for me to appoint an attorney to represent you?
I do not.
Let me tell you some of the ways a lawyer can help you in deciding whether to enter a plea. A lawyer can advise you as to whether entering a plea is in your best interest. A lawyer has the experience to help you work with the state and even bargain for different terms. A lawyer can tell you the advantages and disadvantages of what you might say to the court during your plea hearing and the sentencing hearing that will follow. Do you understand that you will not get any special consideration from the court just because you are representing yourself?
I do.
Do you understand how necessary a lawyer is and how he or she could help you?
I do. Or don't.
Well, do you understand
I do.
the possibilities? Okay.
Sorry about that.
You understand everything that I said?
Yes, I do.
Okay.
Most definitely.
Mr. Vordenbaum, you're charged with driving while license suspended, habitual second or subsequent conviction. Do you understand those charges against
I do.
you? Have you received a copy of those charges? Have you seen the information?
Yeah,
Do you understand the serious nature of the charges
I do.
against you?
Most definitely.
The maximum sentence against Mr. Vordenbaum would be what, 5 years?
5 years in prison, Judge, and he does score over 22 points, so he would be prison eligible.
Okay, thank you. Mr. Vordenbaum, do you understand that you could be sentenced up to 5 years in prison?
I do. But I do now.
Do you still wish to represent
yeah.
yourself? If you're found guilty, again, you can be sent to prison for 5 years. You could be put on probation. You'd have to report to probation or community control. You may have to pay a fine. Do you understand those possible sentences?
I do.
You also would be a convicted felon, so you would have a permanent criminal record. Do you understand that?
I do.
Do you have any questions about any of the consequences if you're found guilty of that charge?
No, I guess so. I'm good.
Okay, so let me tell you some ways that an attorney can help you during trial. A lawyer has the experience and knowledge of the entire process. Your lawyer will argue for your side during the whole trial and present the best legal argument for your defense. Since jury selection is governed by lots of legal procedures, a lawyer's knowledge and experience may give a lawyer an advantage during the selection process on your behalf. A lawyer can call witnesses for you, question witnesses against you, and present evidence on your behalf. A lawyer can advise you on whether you should testify, the consequences of that decision, and what you have a right not to say. Do you still wish to represent yourself?
I do.
A lawyer has studied the rules of evidence and knows what evidence can or cannot come into trial. A lawyer can make objections during the trial to try to keep certain testimony and evidence from being introduced at trial. A lawyer may provide assistance in ensuring that the jury is given complete and accurate jury instructions. The attorney may make effective closing arguments on your behalf and may prevent improper arguments by the prosecutor. A lawyer may ensure that any errors committed during the trial are properly preserved for appellate review later by a higher court. Do you understand those, that expertise of an attorney?
I do.
Do you wish for the court to appoint an attorney?
I do not.
If you are convicted, a lawyer may prepare for a sentencing and make sure that favorable facts are brought to the attention of the court. A lawyer may make sure that the court is aware of all legally available favorable dispositions. A lawyer can make sure a proper pre-sentence investigation report is prepared on your behalf. A lawyer may help bring witnesses to court to testify on your behalf at sentencing. A lawyer may make sure that any sentence is lawfully imposed. An attorney's legal knowledge and experience may be useful in filing an appeal and in seeking release on bail pending that appeal. Do you still wish to represent yourself?
I do.
Okay, I think this may be the last section. As it is almost always unwise to represent yourself in court. I have to smile on that because in law school they tell us when we're practicing, especially first year, we think we know everything, and they tell us, if you represent yourself as an attorney, you're representing a fool. And so they just tell us that. So as it is almost always unwise to represent yourself in court, let me tell you a few of the disadvantages of representing yourself. Do you understand that you will not get any special treatment from the court just because you are representing yourself?
I do.
Do you understand that you will not be entitled to a continuance simply because you are representing yourself?
I do.
You will also be limited to the legal resources that are available to you. You will not be entitled to any additional, there won't be any additional privileges provided to you other than what is available to a layperson. Do you understand that?
I understand.
You are not required to possess the legal knowledge or skills of an attorney in order to represent yourself. However, you will be required to abide by the rules of criminal law and the rules of courtroom procedure. These laws took lawyers years to learn and abide by. If you demonstrate an unwillingness to abide by these rules, I may terminate your self-representation. Do you understand that?
Yeah, I do.
Do you understand that if you are disruptive in court, that I can terminate your self-representation and remove you from the courtroom, in which case the trial would continue without your presence?
I do.
Okay. Do you understand that your access to the state attorney who is prosecuting you will be severely reduced as compared, well, I don't know if that's true. You're not incarcerated, so I think you have the same access that an attorney would have.
Well, talk to her anytime, can I?
I'm sorry?
I can talk to her at any time, can I?
Yes, sir.
Okay.
If you are convicted, you cannot claim on appeal that your own lack of legal knowledge or skill constituted a basis for a new trial, or constitutes a basis for a new trial. In other words, you cannot claim that you received ineffective assistance of counsel. Do you understand that?
I do.
Do you understand these dangers and disadvantages of representing yourself?
Somewhat, yeah, I guess.
Well,
I do understand.
Do you have any questions about anything that I just said?
Not really.
And I know you're laughing, but, you know, at the end of this, the consequences could be really dire.
I understand.
So if there's anything that I've said that you don't understand, this is the time to let me know.
No, I understand.
Okay.
Yeah.
Were you ever represented by counsel in this case?
No, sir.
Okay.
Nor the other 26.
I'm sorry?
I said nor the other 26.
Judge, I hate to interrupt.
Yes, ma'am.
But I do want to make sure, while we're going through this process, that we're clear on where we're at with the case.
Okay.
So that way Mr. Vordenbaum can be questioned about his understanding. Mr. Vordenbaum has not engaged in any plea negotiations regarding this case whatsoever. The state would make on the record today, the offer would have been an adjudication of guilt and credit for time served. Now, if we
would have been or is today?
It is still today, Judge,
Okay.
but after today, that's going to expire. Mr. Vordenbaum has previously pled at least 3 times to felony driving license suspended. So if we were to go to trial, then the state will be seeking incarceration for Mr. Vordenbaum if he is convicted after trial. Now, I know Mr. Vordenbaum in prior motions and then again in this motion to amend a motion to suppress is making allegations regarding conspiracies and things like that. The state has prepared a motion in limine to prevent Mr. Vordenbaum from discussing these matters if we proceed to trial. I have not filed that motion in limine because it seemed a little preemptive to do that when we still were going to discuss motions to suppress today. So I was waiting to find out how the motion hearings went today before I completed my motion in limine and provided it to the court. My anticipation was to provide it by 5 o'clock today to Mr. Vordenbaum and to the court, so that way it can be ready before the jury comes in or the venire comes in
On Tuesday?
On Tuesday, yes, Judge.
Okay. Okay, thank you. Mr. Vordenbaum, do you understand the state's offer?
I do.
Do you wish to accept it?
I do not.
So, Mr. Vordenbaum, separate colloquy, set of questions that I ask you and that I ask you to answer, just to make sure you're competent to do what you're asking to do. Like it said before, you don't have to have legal knowledge, but I need to make sure that you're competent to make the decision to represent yourself. So how old are you?
50, I'll be 54 in September 29th.
Okay.
53.
Can you read?
I can.
Can you write?
I can.
Do you have any difficulty understanding English?
No, sir.
How many years of school have you completed?
16.
Okay. Are you currently under the influence of any drugs or alcohol?
I'm not.
Have you ever been diagnosed or treated for a mental disorder?
I have not.
Do you have any physical problems which would hinder your self-representation in this case, such as hearing problems, speech impediment, or poor eyesight?
I do not.
Has anyone told you not to use a lawyer?
Everyone. No, I'm good.
I mean, do you feel coerced to not use a lawyer because somebody's told you?
No, I'm good.
Okay. Has anyone threatened you that if you hire a lawyer or accept a lawyer appointed by the court, has anybody threatened you?
No.
Do you understand that a lawyer appointed by the court, if you qualify financially, will represent you for free?
I do.
Have you ever represented yourself in a trial?
Not in a trial, but no, I'm not.
Do you have any questions about having a lawyer appointed to defend you?
I do not.
Having been advised of your right to counsel, the advantages of having counsel, the disadvantages and dangers of proceeding without counsel, the nature of the charges and possible consequences in the event of a conviction, are you certain that you do not want me to appoint a lawyer to defend you?
I am certain.
I also want to make clear, Judge, because this has come up in a few trials recently, as far as the bond situation, that we make sure that we discuss that. If Mr. Vordenbaum is convicted at trial on Tuesday, the potential that he would be taken into custody immediately on Tuesday.
Mr. Vordenbaum, do you understand that?
I do.
Okay. Still wish to represent yourself?
I do.
Okay. And all of that's done, to just make a lot of people that have stood where you stood have gone through a lot of those questions And the last one that I remembered that said, no, I think I want an attorney, was when I said about appellate purposes. Do you understand that an attorney can preserve the record if you want to appeal it? And that was what I finally think that defendant said, no, I don't understand this. I'm going to let somebody represent me. So you still want to represent yourself?
I do.
Okay. So, Mr. Vordenbaum, since I haven't read your motion, why don't we take, we'll take private counsel that's in the gallery. Then we'll take a short break. I'll read through this, and then I'll hear your motion to amend, okay?
Sure.
So if you'll have a seat in the gallery. Mr. Shaw? How was Judge Wells?
I'm sorry?
How was Judge Wells?
He was good today. He was punctual.
You had to think you were on the record, so.
Yes, I appreciate you letting me appear here second.
Yes, absolutely.
Judge, first case I have on the docket this morning is Marcus Lee Lane, 22 CF 994. At this time, Mr. Lane would withdraw his previously entered plea of not guilty, tender a plea of no contest as charged. Count one would be 36 months probation, 48 hours community service work. If no violations and all requirements are completed after 18 months, the state will not object to early term. All fines, costs required by statute, rule, or ordinance, $50 a month cost of supervision. As to count two, it would be 12 months probation concurrent with count one. He would be adjudicated on both charges. It is a departure, Judge, legitimate uncoerced plea bargain.
Okay, thank you.
We'll provide a score.
Yes,
We'll
sir.
provide a score sheet at a later time, Your Honor.
Okay, yes, sir. Thank you. Mr. Shaw, you mentioned $50. This is going to be by probation, so it's $40.
I'm sorry, Judge, $40 a month.
Okay, you're thinking about misdemeanor.
I get it, yeah, that was the JCS amount.
Exactly. Mr. Lane, if you'll please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Lane, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Lane, I do accept your plea. You're adjudicated guilty. You're sentenced to 36 months probation in count one, 12 months probation in count two, to run concurrently, run at the same time. You'll need to perform, yes, sir.
Oh, sorry, no, I just wanted to make sure that we get is the score sheet that we provided in discovery acceptable?
Yes,
for the defense
yeah,
counsel?
that is
I just wanted to make sure that we had that on the record so that when we provided it was acceptable.
I had reviewed the score sheet that was provided in discovery with my client, and it is accurate.
Okay, thank you. Mr. Lane, you'll need to perform 48 hours of community service work. This is a downward departure. You'll need to pay the $40 per month cost of supervision and the court cost. Interesting the way that you said the 18-month period. You're saying if he moves for that, so it's not automatic at 18 months?
That's the agreement with the state judges.
Okay.
We had that discussion.
We're not going to have any objection, Your Honor,
Okay.
if after that.
So, Mr. Lane, at the 18-month mark, if you haven't committed any new law violations and have fulfilled all the terms of your supervision, you can move to terminate your supervision, and the state stipulates they agree that they won't object to that. Okay? Thank you, sir. Good luck to you.
Thank you.
Judge, may I take Marquis Dewberry next? Judge, this is Mr. Dewberry, 22 CF 1218. I think the court is aware that Mr. Flowers and I were just retained on this case. I think the court signed a order on stipulation for substitution of counsel in the last day or so. Mr. Flowers had filed a motion to continue the case based on just getting the case. I don't think the state has any objection. I've talked to Mr. Dewberry about it. He doesn't have any objections. It continues as well.
That's correct, Your Honor, especially given the nature of our trial cycle. This cycle, the state has no objection to continuing this. We would want to make sure that it's very clear we want a trial next time, though.
Okay. Mr. Newberry, I'll see you on November 13th at 9 o'clock. If the state offers you something that you want to accept before that date and you want to avoid about 300 people, Mr. Shaw can set a hearing before then, okay?
Yes,
Thank you, sir.
thank you.
Thank you, Judge. Judge, in the last case that I had on the docket was Joshua Lee Lopez.
Yes,
That is a PTI. It was sent to my client, I think, on Monday. I'm just waiting on it to get back. I was told it would be back today. If you want to put it on a miscellaneous day, if you got a shorter one we don't need to wait till November 13th, but.
It's up to the state. Do you want to set it just at the next pretrial, or do you want to set it before that?
I think we could just set it, October 16th, I believe, just a miscellaneous date as a status holder, the idea being that it will fall off the docket before then.
Okay, so the case itself will be set for November 13th, but it'll be set for a status October 16th at 9. Okay.
Thank you, Judge, and I believe that's all I have.
Thanks, Mr. Patton. Okay. Other than Mr. Vordenbaum, the other folks in the gallery, what are they waiting? Okay, so we got to wait for Mr. Catalina. And who's the other one? Okay, good. Okay, we'll take a 15-minute recess, and then we'll come back. I'll read through the motion. I'll also bring you up to speed. On what Judge Ketchell's JA just said, that he has a civil jury trial both next week and the next week. So what he was telling me was not exactly accurate. But I will double check that. I'll go talk to his office and him if he's off the bench, and I'll talk to y'all in 15 minutes. Thank you.
All right, please.